The information discussed in this webinar is current as of the date noted and is for informational purposes only and does not intend to address the financial objectives, situation, or specific needs of any individual investor. Any information is for illustrative purposes only and is not intended to serve as investment, tax, or legal advice, since the availability and effectiveness of any strategy is dependent upon your individual facts and circumstances. Results will vary, and no suggestion is made about how any specific solution or strategy will perform in reality. The information in this webinar is to be used as a guide for estate and legacy succession planning. No two situations are alike. Therefore, every estate plan is different. At JGUA, we do not execute legal documents, but instead review estate plan concepts with our clients to align their financial goals with the best legal structure and associated documents. We also help coordinate with their attorney and designated agents to execute their wishes and assist with the implementation of the client's executed estate plan. First question is going to go to Pete. So Pete, the question that was submitted during our registration process: what are some of the best strategies to leave property to my family?
That's going to depend upon your objective of why you're leaving it. We see a lot of different situations, just to name a couple real quick. Sometimes it's a family property that is deemed to be a family legacy. That it could be a lake property, a mountain home. And in a lot of those cases, people will set up family limited partnerships, LLCs, things that actually go ahead and transfer that property during life. Other circumstances could be you just leave it as part of your will or your living trust. If it's simply you want to leave it to your children or grandchildren or anybody else, those are always going to be kind of the simple options for you. I have a case that I've recently been advising on of a woman who has a housemate, somebody that is a close friend, and they now live together. And she's concerned that if she predeceases her friend, that her friend won't have a place to live. And frankly, it's going to be relatively simple. Nothing happens until this woman's death because nobody knows which of the two is going to pass first. So there's provisions right in her will that if this housemate survives her, that then a trust under the will be set up. So this is a long ways of saying that's a hard question to answer without knowing the specifics. But such planning is very, very common. We see this a lot of times. And somebody like us or attorneys and other advisors would be able to deal with the specifics of that.
Sarah, any additions you want to make to Pete's answer there?
Yeah, I think where it comes into the question of why it's so hard to answer is, what defines a best strategy? Totally depends on what your goals are and what you're trying to accomplish. If at the end of the day you're trying to streamline the whole process for when you pass away and everything transitions over to whoever's going to be inheriting your estate, then potentially a best strategy might be those that are in line with trying to avoid probate. So it kind of goes back to, again, what are you defining as your goals that might be in line with us determining, both with an attorney, what our best strategies to utilize.
Okay, we will go ahead and move to our next submitted question. And Sarah, you can take the lead on this one. What steps can I take now to minimize the inheritance tax my daughter will need to pay? Is having her name on property deeds one of them?
Well, first, I kind of want to at least open up and say that these are all really great questions that have been asked today. And we're really glad to see this level of engagement with these questions. They're They're hard to answer, but hopefully we're able to at least offer some guidance. We're not practicing attorneys, but we'll shed on some light on how we might work with an attorney and our clients and helping them determine what might be in ultimately the best interest for them. So with this one in particular, it really does depend on, if we're talking about true inheritance tax or if we're talking about estate tax. Again, inheritance tax is going to be the tax that is levied on the individual that's inheriting from the estate or as the beneficiary, whereas the estate tax is the tax that's levied on to the actual estate itself when after it's been or before it's being administered and divided out to the beneficiaries. Starting to work a little bit particularly on Pennsylvania personally, because I do have some clients that are in Pennsylvania that are impacted by inheritance tax. With that being said, there's some potential strategies with owning property jointly, but I always caution that because even though it may protect half of that asset, if you're talking about owning it with one other person, protecting half that asset from being taxed, you're also giving up part of your ownership rights. And with that being said, if you ever decide to sell that property or if you decide to sell the property, you have to have both individuals consent to selling the property. The other complication is, let's say, the other joint owner has creditors that are looking to attach their lien against that property. Well, you're just subject to that property to some risk. So to really answer that question, really needs a personal consultation with the advisor and an attorney that might be able to help navigate that discussion a little bit better.
Pete, anything to add to Sarah's answer?
Well, there's long been strategies that revolve around this ideal of people will move assets to family members during life, simply kind of freeze the value of that property at today's value. So if you make a gift, if you have a property that's worth $500,000 and you think it's going to appreciate over time, people will change the title on that today to freeze that value with the ideal that now instead of having to pay estate tax or inheritance tax on that higher value, they're going to be basically using up some of their lifetime exclusion on the lower value. Very long-standing policy, and frankly, that has some value to it. But with the current estate tax exemption amounts, it's not as popular of a strategy today. I remember when it was 600,000 was all that was exempt from state tax. Under the current legislation that expires at the end of 2025, it's approaching about $13 million a piece. So jumping into these things without really understanding if you're going to be paying inheritance or estate tax can really be just wasteful. So again, getting all the financial specifics, the size of the estate, the situation of the person that you might put on that deed or transfer the property to are all very important considerations.
How can I pass my home to my child tax-free and stay in it until I pass or have to go into assisted living?
So I'm just gonna, and I apologize, Ryan, about not mentioning this before, but I'm gonna change that question a little bit at the end and say if you have to go into a nursing home. And I think in part this kind of goes in line with Medicaid planning. And with that being said, a lot of times when we're doing this type of planning, if it's needed for working with clients, we are working with an attorney who specializes in Medicaid planning just because it's so nuanced. It depends on the state and sometimes even the counties on how they look at available assets. It's really, depending on how the county works as well. So a lot of times, again, we're working very closely with estate planning attorneys that have this specialized areas that part of their practice. So I'm just going to highlight on a couple of potential strategies that might be useful. But again, these are not recommendations and really need to be consulted with an attorney on these. One of them is a irrevocable trust or a Medicaid trust, and that's where assets go into this trust, and ultimately the owner no longer has ownership rights over these assets, and they don't have the ability to control and move the assets in and out. Again, you're looking at that 5-year look back period if we're talking specifically at about New York State residents. There's no step up in basis with this potentially, which could lead to capital gains taxes in the end if that property does get sold. There's the New York State Medicaid caregiver's child exemption, which may be applicable in some circumstances when you have maybe an adult child who moves in for a certain period of time and helps take care of the individual. In a way, it's the idea behind it is that adult caregiver is keeping that person out of the nursing home for an extended period of for that period of time when they might have already have been in there had they not moved in. With those cases, though, again, if that person decides to sell, they receive the property and then they decide to sell it later on, potentially there could be some capital gains taxes because there's no step up as if the person were to inherit it through death with that step up in basis. And then there's the more classic that we tend to see is a life estate being used for Medicaid planning, which basically is the person that owns the house, they retain a life estate interest in that property, and the deed then severs that remainder interest, so that perpetuitous interest, when you pass away, that goes to the remainder men. So your children, for example, could be having that remainder interest, and that when you pass away, the next generation that inherits that in the deed, they still get that step up in basis. So if they were to sell that property afterwards, it would be potentially less of a capital gain. But that being said, there's a lot of caveats to this type of planning, because if you are ending up going into a nursing home and the property is rented, some of that monies from the rent could be used towards as an available asset and help taking care of you while you're in your nursing home. And then also, should the property be sold while you're still alive, you still have a certain interest in that property, which has a monetary value. So when you sell that, that would be available to Medicaid as well.
Pete, anything to add?
I want to share kind of some of the experiences that we've had working with people. And with these Medicaid trusts, you really need to be careful. Something that we've seen as a number of years ago, I was introduced to a situation by a couple's children, really, that had a Medicaid trust set up, and it was well drafted. The attorney did a good job with it, and assets had been retitled correctly. The house and investment accounts and so forth had been retitled into the trust. And a number of years had gone by, and this couple had used up all of their assets, essentially, that were not in the trust. They had aged, but they were not at the level where they need skilled nursing or a lot of high-end care, but they wanted to essentially sell the house, move into a quasi independent living, assisted living situation, and would not qualify anyway, anyhow, for Medicare. And guess what? They didn't have any assets to be able to fund this chosen lifestyle. The result, to make a long story short, was the trust was broken. They went back and basically undid it. It was always this assumption that they would have enough assets that to qualify for Medicaid, they would be in a nursing home. That's just not the way it played out. So you have to do very careful planning with this to have these contingencies in place for the what ifs.
Okay, we will move to our next question. This one was going to go to Pete. What are your experiences with unique assets such as art collections, yachts, or rare collectibles, and how they factor into estate planning?
I think we talk about estate planning, we think of all the legal ramifications, but I think this is one that has a lot of practical ramifications. A couple of examples here. Um, Somebody that we had as a client had passed away, and his sons were helping with the estate, and it was really remarkable. The man had a very, very substantial stamp collection, U.S. stamps, and he had preserved them. They were cataloged. Not only were they cataloged, he had paid for them, and he had assigned valuations to them at some prior point in time, and also had left very, very specific instructions of how the family should dispose of these so that frankly they didn't get ripped off. Who were the reputable stamp dealers and brokers and stuff that they could deal with? And it worked out well. The two boys followed those instructions. They got them to the right people, and they probably did as well, liquidating those and getting proceeds as one could have expected that they would do. Another situation where um, there was some assets, some collectibles, basically, I guess is the best word for them, that it was intended to uh, remain either in the family or go basically to a good home. They didn't want to ever do this in a fire sale, and believe it or not, there was I guess it was a corporation set up basically just to hold those assets outside of the estate. Really wasn't done so much to freeze the value of the assets, just to give a long runway on dealing with those assets after death. The question that was presented talked about yachts. I haven't had anybody with a yacht that we've been that concerned about. But there are solutions, good solutions to dealing with things like this on the practical side.
Anything to add, Sarah?
Yeah, I think I'll just add that currently I'm working with quite a few clients that have these type of collections, whether it's car collections, coins, radios, dolls, the teddy bear, stuffed animals, and it's so hard to have, I think, some of these discussions with my clients because you have to think about what to do with those assets. And if you don't know anyone, particularly in the family, who might be interested in those assets, could that potentially, depending on how large that collection is, end up being maybe a slight burden on them in the end when they're trying to consolidate ultimately and sell things off? I know, Pete, you and I discussed a little bit before about having really good documentation on all of this. If there's any, what you paid for it, having documentation on maybe who you could, who your and the administrator of the estate could go to liquidate some of these assets if there's nobody that is interested in keeping them. But I think one thing to consider is if it's going to be something that might be a little bit burdensome to liquidate, is potentially either during your lifetime, if nobody has interest in it when you pass away, during your lifetime, liquidating it, whether it be you sell it or giving it to a charity, or even figuring out a charity for when you pass away and name it in your will potentially as someone who'd be interested in that donation. But of course, it's so hard with collectibles and trying to figure out when's the right time to come up with that decision of disposing of and liquidating your collection. I know myself personally, I'll share, I have a collection of Ginny dolls and sewing machines, and the sewing machines at least have some actual use value to that. You can actually sew with them, but the Ginny dolls, there's likely no value in those anymore compared to what I paid for them, and I don't have anybody who'd be interested in my family to keep them. So that's always one thing they always think about is what am I going to do with these, and when's the right time to potentially consolidate and dispose of them.
And again, the person who's done the collections is usually the best informed. And the conversation makes me think back a number of years ago to a woman who had some quilts that she had produced. And I don't know much about quilting at all, but there's different styles of producing these quilts. And the style she used, the method was unique. And these quilts had some really good value. So during her life, she began to contact museums who had quilts to make sure she could find a museum that understood the value of those quilts because of the unique way that she made them. And all of that was set up. And the only thing that happened upon her death was the quilts got shipped from Arizona to a museum in New England. So it's just planning is all it was.
All right, we'll go ahead and move. We're in our last couple of questions here. Sarah, how often should I be reviewing and updating my estate plan and will?
This is always a harder question, but I think generally at least every 5 years seems to be a good rule of thumb. But of course, a lot of that depends. Looking at maybe when you have other variables and when you may need to update your estate plan or will is you have acquired or you dispose of assets. You personally have moved, or maybe you have family members that you were looking to inherit it. Some of your assets have moved, which may require additional planning, especially if you're dealing with estate or inheritance tax. And there's a change in the family tree. So maybe, unfortunately someone's passed away, or maybe your children had had their own children or have great grandchildren. And as the tree gets bigger, you might have to do some additional special planning for that. So again, it depends. There's also the change in legislation that happens, whether it's at the state level or at the federal level with exemptions, estate tax exemptions changing. Personal health situations could change, what might render you changing how you have things structured in your will or who you would have named as a healthcare proxy or power of attorney. So really, whenever there's a little bit of change, which is why I always recommend keeping up to date with any type of changes with working with financial advisors, because if something happens in your life, hopefully they're on the other hand thinking, hey, this is triggering a potential change that we need to make to your estate plan. And then they quarterback working with the estate plan attorney to make sure that those are followed through.
Anything to add, Pete?
No, I think not in particular. I think Sarah has kind of nailed that. I think probably the biggest reason I see changes was two. I think because of circumstances, it becomes obvious that a named executor or a trustee is no longer the right person to do it. So changes are made for that. The other one, less common but still happens, is the family circumstances have changed. And maybe there's somebody who was set to inherit and they've done very well and they don't need it and their siblings do. So just, the practical sides of it. But it's good to look at them. We have a lot of discussions where we review a will, and at the end, we do nothing. But everybody knows at least it's in good shape.
All right, Pete. So that'll take us into our last Submitted question for the session today. What should I do to ensure my family is educated and prepared to handle my estate when I'm gone?
Have conversations with your family. It's that simple. The generation before me and stuff were very secretive about their finances. Even now, we still see that where there's surprises. Have records, have somebody in the family know where those are. To some extent, have them understand your intentions, what you're thinking about, why you structured the things the way you did. And there will be sensitive situations where maybe not everyone in the family needs to know the details of that structure. But somebody needs to be able to step in, and that's usually going to be the person that you name to be executive of your estate. So don't surprise them. Have the conversations, even if they are difficult. And a really eye-opening experience I had was had a client, and she was an only child. Her parents actually lived not far from where they were, and the topic had come up about their parents and whether or not she might have an inheritance. And she said, I really don't know anything about my parents' finances or how much they're worth or anything. I encouraged a conversation. And when she brought the topic up, her father said, we've been waiting for you to ask. Well, the lesson there was somebody had to start the conversation, and I guess it wasn't going to be her father. So engage in that conversation at the right time, the right place, with the right
Anything to add, Sarah?
No, I think just having the conversation, and if you're going to be naming someone as a healthcare proxy, power of attorney, make sure that they have some idea of what might be expected of them, and where your finances are. They should definitely be a little bit more in the know than, say, someone that might be in the end inheriting part of your estate. But then also the executor as well, having, whoever you have as the primary or ultimately the successor. In many cases when we're working with married couples. So that way they have an idea of at least where the important financial documents can be located, whether it's with, contact my financial advisor. Here's all their contact information. In some cases, I've worked with some clients who have been very thorough in preparing their family for their passing, and they have provided detailed information notebook on everything from health situation with their doctor's information to financial records. And as much as you can have that conversation and feel comfortable sharing information, it will make things a little bit easier and less stressful, because remember that whether you're dealing with someone who's you're required to step in as power of attorney, a healthcare proxy. It's stressful and very emotional. And then when they're dealing with the added layer of trying to help with financials and get their head wrapped around health situations, it does add to the stress. And so whatever you can do to help minimize that stress is beneficial. And then of course too, when someone passes away, that's very emotional. And when you're trying to figure out where all the assets are, and then ultimately the executor trying to figure out how to distribute the estate to the beneficiaries, whatever you can do to make that a little bit easier and streamlined is going to be ultimately to their benefit, when they're dealing with that grieving process.